Mr. Chairman, ladies and gentlemen, I'm acutely conscious of time as well, and I'm going to try and compress my paper into some 6 or 7 minutes if I can. It's a pleasure and an honour for me to be asked to address you on this historic occasion, because I'm conscious of the fact that my address may fortuitously serve as a link between the last occasion in which the Constitution was comprehensively reviewed and today, because I had the good fortune to be a member of the Constitution Review Group of 1995 to 1996, which reported in May of 1996. There's a paper there which I can invite you to read at your convenience. I was asked to say something about the 1937 Constitution and how it came into being. Essentially, in 2 or 3 sentences, one can say that in 1922, as the British evacuated this building, Michael Collins set up a committee to draft a new constitution. They come up with many innovative ideas which are found in the 1922 Constitution, including the very radical idea of judicial review, that is to say that the courts could review legislation and find it unconstitutional on the basis that it infringed constitutional rights or human rights. That was a radical idea at the time. They borrowed from Switzerland the idea of a referendum and direct democracy, something that is with us to this day. And they also looked in particular, we know, at the constitutions of many of the emerging countries in the wake of the First World War. In particular, a constitution that I'm going to say a little bit more about in the course of the next 5 or 6 minutes, of which you probably haven't heard. The Weimar Constitution of 1919, which was the constitution for Germany after the First World War, very highly admired constitution. It is in many ways the grandfather of every single constitution in Europe to this day, and is very influential in 1922 and in 1937. Now, the 1922 Constitution wasn't a success. That's a long story, but in 2 sentences we could say it contained a major drafting error which led to its collapse. Incidentally, it was the same drafting error that led, with tragic results, to the collapse of the Weimar Constitution in the 1920s and 1930s. Secondly, the 1922 Constitution was bound up with the Anglo-Irish Treaty of 1921, and as that treaty was gradually dismantled in the 20s and 30s, the seams of the 1922 Constitution came apart, essentially. The drafting of the Constitution of the present Constitution started in earnest in mid-1934, when Mr. De Valera, who was then President of the Executive Council, or Taoiseach as we'd call him today, set up a top-level committee to review every single feature of the existing Constitution, 1922 Constitution. They reported to him, recommended that a good deal of it should be saved and preserved, but recommended other significant changes. And in April 1935, Mr. De Valera instructed a really remarkable civil servant, again, probably you haven't heard of, John Hearn, who is the legal advisor to the Department of Foreign Affairs, to prepare the ground for drafting a new constitution. And the yellow note that you see, the so-called square paper draft, which I think is somewhere, yes, here, on the logo, that those are De Valera's own notes of his conversation with John Hearn in April 1935, where Hearn sketched out his ideas. And of course, there was mutual exchange between the two men. And you can see in the paper, I set out in 2 or 3 pages, just the actual drafting history. Suffice it to say that there were influences from a lot of sources, judges, Department of Finance, Department of Justice, clerical figures, including Archbishop, then Father John Charles McQuaid, whose role, I think, has been somewhat overstated. Another Jesuit figure, Father Edward Cahill, who prepared a submission to De Valera in October 1936. And that was very, very interesting and very influential, because it wasn't a specifically religious document, really, but what they did was that a Jesuit committee met. They had before them the English language versions of a lot of interwar constitutions, and they took those, did a kind of a scissors and paste job very elegantly, and took a few bits and pieces from papal encyclicals, stuck them together, and submitted them to Mr. De Valera. And a lot of that, or a good deal of it, found its way into the 1937 Constitution. And then then, of course, John Hearn did most of the drafting, aided by a particular committee, and there's lots of contemporary material on that for those who are interested in it. It was adopted by a single-chamber Oireachtas in May and June 1937, voted on by the people in July 1937, the first constitution ever to be put to a popular vote, and then came into force on the 29th of December 1937. And since the end of June 1941, that's 3 years after the first president was inaugurated, it can only be amended by referendum. For those of you who've got my paper, if you look at page 3 and page 4, you'll see where I say the sources of much of this material came from. And I believe that the Weimar Constitution of 1919 served as the basic model and the basic template for Hearn. It was used in 1922. It was used by the Jesuits in their document, or similar constitutions from the interwar period in their document, and also used by Hearn. And essentially, there was, you'll see a hodgepodge of various different influences from various different constitutions were used by Hearn and the drafting committee to put the constitution together. Now, I think it's easy to point to the Constitution's obvious faults and flaws. Those are well documented. I wouldn't wish to trespass into the domain of political controversy but in my present position, but I think it can be said that some of the more nationalist and religious references which remain do not match the prevailing social and political culture of this state as well as they once did. But what I personally find intriguing is the extent to which the Constitution's obvious strengths and considerable achievements are almost never mentioned in public discourse. And in the period since the Constitution was enacted, there have been over 75 declarations of unconstitutionality, that particular laws and rules were unconstitutional. Such laws preventing access to contraceptives, discriminatory taxation of married couples, arbitrary taxation systems, laws interfering with court business, discriminatory rules regarding elections, discriminatory rules regarding juries, discriminatory rules regarding preventing men from adopting, rules giving men the ultimate say in the rearing of children, and a host of other similar types of cases have created a huge corpus of case law. And much of this today seems either to be forgotten or to be taken for granted. The list of major decisions could be much extended, but nobody can underestimate the absolute centrality of the Constitution in our legal system. The verdict of our greatest constitutional scholar, the late John Kelly, in 1980 was that the Constitution had produced results which were, on the whole, beneficial, rational, progressive and fair. If time has made that verdict safe from review, it's nonetheless, I find, depressing to think that much of the public discourse in this area is dominated by the comments of the hypercritical and the ill-informed. Much of the criticism of the Constitution seems directed at the proposition that many of its provisions are unique and special to Ireland, redolent of an agrarian, nationalist and very religious society that is no more. I seriously dispute that proposition. I think you would rather find that much of the Constitution has very close comparators, for all the reasons I've just mentioned, with its continental counterparts. The fundamental rights, equality, liberty, family, education, children, the home, free speech, and so on, are protected in very similar language and in a very similar fashion that represents part of the common European legal heritage since the French Revolution. And you'll find words like inviolable, inalienable, imprescriptible, respect, and so on, which are dotted throughout our Constitution, also dotted around the constitutions of the major European continental states. And I'm going to give you one or two examples before I close, ladies and gentlemen. First, Article 40 of our Constitution protects the inviolability of the dwelling, or the sanctity of the home, one might say. The exact same language, inviolability of the dwelling, can be found in the constitutions of Germany, Italy, Belgium, and Denmark, and similar language is found in a variety of other continental constitutions. Most continental constitutions also protect the family and the right to education, even though I think most Irish people have been led to believe that the provisions dealing with family in Article 41 and Article 42 are unique and exceptional to Ireland. Thus, for example, Article 42 refers to the inalienable right of parents to rear and educate their children, and both the old Article 42.5 and the new Article 42A, assuming the Children's Rights Amendment goes through, and I better not comment on any court cases, but assuming it one way or the other, they both allow for the state to step in where parents, quote, fail in their duty towards children. Yet Article 6.2 of the German Basic Law of 1949, their constitution, says that the care and upbringing of children are, quote, a natural right of parents. And Article 6.3 of the German Constitution allows the German state to intervene where the parents, quote, fail in their duty to their children. Is there anything so different between the two provisions? Not least given that the exact same language, fail in their duty, is used in both documents. Many of these constitutions have provisions that we would consider odd and eccentric. Nearly all of them have overtly religious references, many of them more striking than anything that was ever contained in the special position of the Catholic Church clause in Article 44 that was removed by referendum in 1972. Many understandably object to the mother and the home clause in Article 41 of our Constitution, but the Weimar Constitution had versions of this, and even today Article 6.4 of the German Basic Law provides for the special protection of mothers and motherhood. And incidentally, it is a fruitful source of litigation at the behest of women's organisations in Germany in relation to matters such as the protection of expectant mothers, child benefit, and so forth. But there's a very similar clause there in the German Basic Law, and it seems to be accepted there. But I appreciate that many people have difficulties with the provision in our Constitution. While therefore some of the criticism of the Constitution's more contentious clauses are all too well founded, the criticisms directed at the bulk of the document generally are not. It appears to be another example of the all too typical Irish characteristics of negativity, lack of self-belief, and lack of civic pride in our institutions and in our own achievements. In early 1865, as the US Civil War drew to an end, Abraham Lincoln wrestled with the US Constitution, which, despite all its great promise, was stained by its recognition of slavery and the Civil War that this had produced. Lincoln was determined that the Constitution would survive, but with the dark stain of slavery removed. The post-Civil War amendments eradicated slavery, guaranteed equality and due process of law, and gave the Constitution that, quote, new birth of freedom which Lincoln had promised at Gettysburg. Our present woes, Mr. Chairman, while acute, do not compare with the dilemmas which Lincoln faced. The promise of this convention, nevertheless, is that should you, and ultimately the people will it, the intentions of the drafters in 1937, as reflected in the Constitution's preamble, that the dignity and the freedom of the individual be assured, can be reinvigorated. That the Constitution, too, can be given a new birth of freedom, which will refresh our democracy, renew our commitment to the protection of human rights, and above all, rekindle a civic pride in our state and its fundamental law, and hold out fresh hope for better times in the future. Mr. Chairman, ladies and gentlemen, thank you very much.